very distinguished and erudite friend and brother, Justice Mahadevan, who has delivered a scintillating speech. Kavita Rameshwar, in my mother tongue Marathi, we would refer to her this evening as the Utsav Murti. There's a language which transcends states and regions and cultures, and I think Utsav Murti is perhaps universal. So, Utsav Murti Kavita Rameshwar, Gayatri Raman, Kavita's parents, Nityanandan and Jayanti, I must compliment you because, but for your careful nurturing, this book wouldn't have seen the light of the day. It all began with the values which she got when you nurtured her. Kavita's spouse, Rameshwar, and beautiful children, Abhinav and Akshara. Well, I hope you'll pardon me a little diversion from what is normally done in these evenings. With Kavita's permission, I would like to share the beautiful bouquet of flowers that she has presented to me, to your parents, to whom we must owe a debt of gratitude. It is always a welcome privilege to be part of an evening that brings us back to the Constitution, particularly when it does so in the form of a book that promises to make us think a little more carefully than we might otherwise have intended. The occasion brings together a book and a set of ideas that invite each generation to reconsider their meaning in its own context. I offer my congratulations to Kavita Rameshwar for a work that invites engagement rather than agreement, and for the intellectual care with which it has been written. When Kavita first approached me to write the foreword, what drew my attention was the manner in which the book revisits a familiar constitutional idea. Due process of law has long occupied a central piece and place in our discourse. Yet it continues to reveal new dimensions when examined through different experiences and moments. As I read the manuscript, it became evident that the work traces the evolution of an idea as it is shaped by courts, by litigants, and the aspirations of a society that looks to the Constitution as a living instrument. Certain constitutional ideas resist being confined within neat definitions. They carry a sense of familiarity, even settlement, yet each generation returns to them with the awareness that something begins to be understood. Substantive due process is one such idea. It has become a considerable distance in our constitutional discourse, accumulating layers of meaning that exceed the vocabulary in which it is commonly expressed. What is striking when one considers the development of substantive due process across jurisdictions is that it has seldom announced itself with clarity. It has often emerged in response to concrete human situations in which the law, as it stood, appeared sufficient, yet revealed its limits in application. In such moments, courts have been called upon to confront a deeper question: whether the law in its substance could justify the intrusion which it authorized. If one looks at the American experience, substantive due process did not begin with questions of personal liberty in which the way we understand it today. In its early phase, it was used to protect what the court described as a freedom of contract. In Lochner versus New York, for instance, a law limiting the working hours of bakers meant as a welfare measure was struck down because it was seen as interfering with the ability of employers and workers to negotiate their terms. That approach came to define an entire period where courts treated economic policy as something the legislature could not easily touch. By the late 1930s, this position was set aside, with the court stepping back from reviewing ordinary economic regulation and recognizing that such matters belong within democratic decision making. What is interesting is what followed. When cases began to involve questions of family life, intimacy, or bodily autonomy, the same constitutional language came to be approached differently. The text remained unchanged. The shift lay in the court's engagement with individuals whose voices had not been fully heard in the political process and who had turned to the Constitution in search of recognition. For those of you who read the newspapers, and I think we are all, as Indians, we are extremely fond of doing so, we have been watching with a great deal of consternation the geopolitical shifts that have been taking place in the Gulf and beyond. The Trumpian policies which have upended world generations and a world of a liberal economic order which was established after the Second World War. A few days ago, a very interesting case was argued in the American Supreme Court. President Trump issued an executive order in terms of which one of the fundamental provisions of the American Constitution, namely birthright citizenship, has been sought to be abrogated in the case of undocumented aliens in particular who have come to reside in the United States. The challenge to the executive order is on the ground that the US Constitution expressly recognizes birthright citizenship as a part of the 14th Amendment to the Constitution. The Solicitor General who was arguing the case said, "It's a new world," he said. 8 billion people are a plane ride away from having a child who is a US citizen. To which Chief Justice John Roberts responded, "It's a new world, but the same Constitution." That highlights really the whole notion of judicial review, particularly in the context of due process. And the case raises fundamental issues. The US was born as a cradle nation, defined not by ethnicity, religion, or geography, but by the ideals of the Constitution. President Trump, interestingly, attended the hearing before the Supreme Court. But as today's article in the New York Times tells us, he left the moment the Solicitor General concluded his argument and before the other side was about to get up, signifying that for those who disagree with me, I have no care for time of patience. There are other cases which are very crucial and which are being argued or which are going to redefine the state of the United States in the world around. Plyler versus Doe, the US Supreme Court said that states cannot stop public funding for school education of undocumented aliens. So even if you are an undocumented alien who has entered the United States, can a state tell that person that we will deny funding for your child to attend basic school education? The Supreme Court had said no. There is a challenge to a law which has been enacted by the state legislature of Mississippi, which allows the counting of mail in ballots if they are postmarked by the election day but received up to 5 days later. Now, what do you mean by election day when you are governed by technology? You can send a ballot by email. So, is it open to a state to say that we will accept ballots which are received postal transmission wise up to 5 days from election day, because that's part of the election process? There is a 1966 law in the United States passed by the Congress in terms of which a non citizen can apply for asylum if he or she is physically present in the US or if they arrive in the US. What does arrive in the US mean? What if someone comes to the point of entry asking for entry on the ground that, well, I am at the US, I'm at the border point? Does that qualify as compliance with the requirement that you must be either physically present in or, for that matter, uh, arrive in the US? Likewise, a very interesting case, Chiles versus Salazar. The state of Colorado banned conversion therapy for minors. The Court of Appeals upheld it. The Supreme Court of the United States reversed it. What is conversion therapy for minors? It is therapy which is intended to reduce, say, the attraction of a minor to a same sex individuals. That was banned by the state of Colorado, upheld by the Court of Appeals, but reversed by the Supreme Court on the ground that it defeats your fundamental right to the freedom of expression. But above all that we have been reading off in the last few months, President Trump's tariffs, where the Supreme Court of the United States, breaking its ideological divisions between Republican judges and Democrat judges, thank God we don't have judges who are categorized in India as belonging to this or that political party, because we are professional judges trained in the law and trained to apply the law irrespective of ideology. But the Supreme Court there held that the president had no power to impose tariffs in the absence of an authorization by their parliament, namely Congress, because imposing tariffs is a product of the right to impose taxation, which vests only in the legislature. And the Supreme Court said that allowing for tariffs would almost give rise to the impression that America is at war with everyone in the world, including their own allies and friends, such as our own country, on whom tariffs were imposed, with whom the country is certainly not at war. We are friends across the international spectrum. So these are some of the modern challenges which the doctrine of due process has thrown up, and which I thought I must share with you. One notices a comparable development in Canada, though it is expressed through a different constitutional language. The Canadian Charter of Rights and Freedoms, adopted in 1982, guarantees under Section 7 that no person shall be deprived of life, liberty, or security of the person except in accordance with the principles of fundamental justice. See the difference from Article 21, which says except according to procedure established by law. Ours was an avowedly procedural due process, which we then, as I will shortly tell you, converted into substantive due process. Over time, the Supreme Court of Canada has given it a rich meaning, asking whether a law is arbitrary, whether it goes further than it needs to, or whether its impact is so severe that it becomes disproportionate to its purpose. These are framed as legal tests, but they carry a deeper instinct. The state cannot simply pursue an objective and remain indifferent to the way it does so, especially when the burden of that choice is borne so directly by individuals. In Germany, the conversation takes place through a different constitutional tradition. The Basic Law of 1949, which was framed in the aftermath of the Second World War, places a strong emphasis on human dignity and limits on state power. Within that framework, the Federal Constitutional Court has developed what is known as the doctrine of proportionality. It requires that when the state restricts a right, it must demonstrate that it acts within its authority and that the measure is suitable, necessary, and balanced in its impact. This is expressed in a precise legal vocabulary, yet the underlying concern remains straightforward. The exercise of power must be justified in terms that make sense to the lives it affects, with formal legality forming only a part of that justification. Framing all this as a choice between activism, judicial activism, and judicial restraint fails to capture what is unfolding. That language suggests a contest of preferences, as though courts are simply stepping in to substitute one view for another. The experience across jurisdictions points to something more grounded. When courts engage with these questions, they are often trying to answer a more demanding concern: whether the use of state power can be justified in terms that respect the dignity of those it affects, even when the law on paper appears perfectly valid. What begins to emerge from these different experiences is that substantive due process is not confined to a single text or jurisdiction. It reflects a broader constitutional instinct that surfaces in different forms. The moment when courts pause to ask whether legality by itself is a sufficient answer, the discomfort around the doctrine perhaps comes from this very feature. It unsettles the ease of clear boundaries and invites engagement with questions that do not yield entirely to text or history. Substantive due process, in a very direct way, asks whether a law that has been validly enacted can still fall short when measured against the lives it governs. There is then a sense in which the doctrine tells us as much about constitutional governance as it does about individual rights. Much of our effort has gone into explaining it in familiar terms, while its deeper implication has received less attention. It suggests that power in a constitutional democracy carries a continuing obligation to justify itself beyond the mere fact of its existence. It is from that standpoint that I would like to suggest two ways of approaching substantive due process, in the hope that they might open up a slightly different conversation around it. One way of understanding is to look at how power presents itself in everyday governance. It rarely appears tentative. Decisions are taken, laws are enacted, actions are enforced, all with an underlying sense that they are justified, sometimes even inevitable. There is a certain confidence that accompanies institutional authority, the belief that having followed the required processes, the outcome must be correct. Our legislatures believe that we have followed the processes, invited a dialogue, and therefore we may be correct and must be correct. Set against this confidence is the discipline that the Constitution seeks to introduce. The Constitution does not take for granted that an exercise of power is sound merely because it has moved through established legislative processes. It leaves room for the possibility that a decision, even when carefully arrived at, may still fail when measured against the lives it touches. This is where substantive due process begins to matter as more than an abstract doctrine, as a way of asking whether the assurance with which the state acts is in fact justified. This becomes clearer when one turns to our own constitutional experience. For a long time, the criminalization of same sex relationships under Section 377 of the IPC was defended as an expression of prevailing morality. It carried legislative authority, drew strength from history, and remained undisturbed within institutional acceptance. When the Supreme Court in Navtej Singh Johar revisited that position, it acknowledged a meaning already embedded within the Constitution. It confronted the possibility that what had been accepted with confidence was in fact an exclusion, one that denied dignity and full personhood to a section of citizens. The same pattern can be seen in the recognition of the right to privacy in Justice K.S. Puttaswamy's case. What these moments also bring into focus is how easily accepted ideas settle into something that no longer feels open to question. John Stuart Mill, while writing On Liberty, cautioned that the opinion which it is attempted to suppress by authority may possibly be true. His concern was not limited to free speech. It was a broader warning about the fallibility of what a society comes to accept as. When placed alongside constitutional practice, that insight acquires a certain urgency. It reminds us that what the law cannot afford to treat as prevailing views as beyond scrutiny, especially when they shape the conditions under which individuals live their lives. That insight finds a natural place within our Constitution. His concern was not limited to free speech. It was a broader warning about the fallibility of what a society comes to accept as. When placed alongside constitutional practice, that insight acquires a certain urgency. It reminds us that what the law cannot afford to treat as prevailing views as beyond scrutiny, especially when they shape the conditions under which individuals live their lives. That insight finds a natural place within our constitutional framework. Substantive due process, in that sense, resists the comfort of unexamined confidence. It asks institutions to explain themselves in terms that go beyond their own assertions, to show that the authority they exercise can be justified when measured against the lives it touches. There is a demanding premise at work. The Constitution recognizes the possibility that power may at times be profoundly mistaken. What also deserves attention is how the law relates to time. A statute is rarely created in the abstract. It emerges from a particular social moment, shaped by the concerns, instincts, and boundaries of that period. Those concerns may be immediate, even compelling, and all that follows often reflects a desire to stabilize that moment, to give it form and continuity. The challenge lies in what follows. Laws endure in a way, they last in a way that the conditions which produce them do not. Laws continue to operate long after the fears, assumptions, or social arrangements that shaped them have faded or changed. With the passage of time, their origins become less visible, and what was once contingent becomes appear to be settled. The law, in this sense, can carry forward the imprint of an earlier moment without inviting us to ask whether that imprint still belongs in the present. What then becomes important is the ability of constitutional thought to discern when a law has outlived the moment that gave it meaning. A rule may once have been in response to a particular social arrangement, a certain understanding of order, even a fear that seemed real at the time. Over the years, that origin recedes into the background, but the law continues to operate. The reasons that once sustained it are no longer examined with the same care. It is here that scrutiny acquires a different role. Not to revisit the intention of the law, but to ask whether the present is still bound by a past it no longer inhabits. One is reminded of George Orwell's observation in 1984. Who controls the past controls the future. Who controls the present controls the past. It is a caution against allowing inherited frameworks to quietly define the limits of current thought without ever becoming consciously reaffirming. Let me dwell on only 3 or 4 examples before I wrap up of what's happening in India today. The Transgender Amendment Bill, which was recently enacted by Parliament, passed through Parliament. The Transgender Bill has taken away a fundamental notion of our law, which in fact just Mahadevan briefly dwelt on, the right of self-determination of identity. Until now, the principle which was embodied in the judgment of the Supreme Court in Nalsa, the principle which was embodied in the judgment of the Supreme Court in Nalsa was a person who claims to be a transgender is entitled to self-determine their identity. Now, the new law which has been enacted requires that the identity of a transgender be certified by a medical professional, opening up anybody who claims the right as a transgender to physical examination, a bodily examination, and really undermining the requirement of self-determination. Or take the case which is now reserved for judgment, the 9-judge bench decision in reviewing Bangalore water supply will tell us which way our country is going to move in the next several decades. In 1978, in Bangalore water supply, the Supreme Court interpreted Section 2J of the Industrial Disputes Act, applying the classical three-quarter test which Justice Krishna laid down. But does India today stand in need of a change in the very definition of the way we will apply industry? Should hospitals be industries? Should clubs be industries? A change in the very definition of the way we will apply industry. Should hospitals be industries? Should clubs be industries? Should voluntary self-help associations be industries? Should universities be industries? Well, these answers which the Supreme Court is going to deliver, make no mistake about it, are going to reshape the very fundamentals of our constitutional history and the nature of our society in the years to come. The Supreme Court said in a judgment which was delivered several months ago that ex post facto environmental clearances are valid. That is to say, that you may have established an industry without an environmental clearance. You have run the industry without an environmental clearance, but it is sufficient that the environmental clearance is granted years later, which is valid, which means that you can be in violation of environmental law so long as you get a clearance later. Now, that judgment has been reviewed, and judgment again has been reserved by the Supreme Court, and I will not therefore say much on that. Or the review, which is now going to be heard by a 9-judge bench of the judgment in Sabrimala. Does the menstrual status of a woman between the age of 10 to 50 define her right to worship? Is worship a public act of an individual commitment, at the same time a collective commitment to pray, to worship, a collective expression of conscience? And can that right be restrained in a public area like a temple? Article 25(2) specifically spoke about throwing open Hindu religious institutions to all classes of Hindus at the birth of the Constitution. If that was permissible, is it permissible to exclude any segment of society, including women, on the ground that you have a menstrual status between the age of 10 and 50? So many of these judgments will redefine India today and India as we intend it to begin. So make no bones about it, that substantive due process, which is here to stay, is redefining the kind of societies that we now aspire to go to. That same attentiveness to how constitutional ideas move through time can be found in Kavita's work. The book approaches substantive due process through its evolution across different moments, keeping its tensions and shifts visible. This restraint allows the reader to see how the doctrine's meaning has been shaped by the circumstances in which it has been invoked, and how those circumstances continue to inform its interpretation. Kavita's attentiveness carries into the way she approaches interpretation within the work. One begins to see, as the discussion unfolds, that meaning is never treated as something that rests entirely at the point of articulation. It is allowed to travel across decisions, across context, and across time, so that its movement remains visible rather than assumed. At one point, Gita writes, "These words prod us in understanding that while the seeds may have been sown in the distant past, the fruits of the living tree called the Constitution must inure to the benefit of an unseen future and to the unknown posterity." The movement of that idea is felt across the work. Interpretation, in her sense, does not arrive at a fixed rest point. It remains engaged, attentive, with losing sight of what has been carried into it. It is within that continuing movement that the work finds its place. There is no attempt to direct the reader towards a single settled conclusion, nor any insistence on closure. Kavita's book does not speak for closure, it speaks for dialogue. The engagement is sustained differently by allowing questions to remain open, by permitting disagreement without anxiety, and by holding constitutional ideas in a state of careful examination rather than resolution. That quality lends the work a certain durability. It remains relevant through its capacity to keep the inquiry alive with seriousness, drawing strength from that sustained engagement. Perhaps that is where the enduring value of substantive due process is to be found. Its significance lies in sustaining careful engagement with questions about how power is exercised, how the individual is situated in relation to it, and the Constitution's role in maintaining that balance over time. A work that carries this engagement forward allows the conversation to deepen with the same care and attention that first gave it meaning. I once again congratulate Vita Rameshwar on this remarkable work and the clarity and thoughtfulness it brings to the field. If I was still in office, After hearing the erudite speech by Justice Mahadevan, I would have appended one sentence: I respectfully agree. But on 11th November 9, 2024, I lost the ability to agree with Justice Mahadevan, at least on the parchment on which Supreme Court decisions are written. But surely, as a citizen, I join Justice Mahadevan and Gayatri Raman in complimenting the author by saying, I respectfully agree, but adding a postscript that we expect much more and many more books from your pen. Thank you.